employees coming from different sources, they were merged into one stream, and whether they will be considered to be the state government employees or not. That was the issue.
Yes.
Here, this is not the issue here.
Well, this is only for the limited purposes that when they have come, assuming Malad for a minute. Firstly, sir, ये
नहीं, मैं आपके जो बेसिक प्रपोजिशन है उससे असहमति नहीं जता रहा हूँ अभी. मैं इस जजमेंट में ये जो रेशो है ये आपको एप्लीकेबल नहीं है, मैं इतना कह रहा हूँ बस. ये जो वेस्ट बंगाल एंड अनदर जो केस ये लगाया है इन्होंने, गुजरात वर्सेस रमन लाल केशव, ये कहता है the question which fell for consideration was as to whether personnel drawn from different sources, namely government departments as well as the local authorities or municipalities, merged together to constitute a single integrated civil service under the state by a legislative enactment would become the state government employees irrespective of their original status. The question was answered in the affirmative. ठीक है, इसमें तो कोई झगड़ा ही नहीं है.
इसमें कोई झगड़ा नहीं. रमन लाल केस was very heavily relied by the Sri Mitra and senior counsel for the respondents since the end result went in favor of the employee and they were held to be holding the civil court. In para 27 of the court observed, we do not propose and indeed it is neither politic or possible to lay down any definite test to determine when a person may be said to hold a civil post under the government. Several factors may indicate the relationship of masters and servants. None may be conclusive. On the other hand, no single factor may be considered absolutely essential. The presence of all or some of the factors such as the right to select for appointment, the right to appoint, the right to terminate the employment, the right to take other disciplinary action, the right to prescribe the conditions of service, the nature of the duties performed by the employees, the right to control the employee's manner and the method of the work, the right to issue directions and right to determine and the source from which wages or salary are paid, and a host of such circumstances may have to be considered to determine the existence of relationship master and servant. In such case, it is a question of fact whether a person is a servant of the state or not. Reference was made to Guru Govind Vasu Solanki Prasad so and so. This court in Raman Lal case noted that the Panchayat service constituted under section 203 of Gujarat Panchayat Act 1962 was a civil service for the state and the members of service were government servant. It was noted that this question was decided by the High Court of Gujarat more than 15 years back in Jail Shugla versus State of Gujarat. The mode of recruitment, the conditions of service and the matter relating to appointment, transfers and promotion of person employed with Panchayat service as also disciplinary action against them are all determined by the state government and that is consistent only.
So आपने स्टेटस चेक कर लिया, अभी रिट अपील तो नहीं लगी इस केस पे? इसको चेक करिएगा जरा, इसको चेक करिएगा. WP 2634/2020 देखिएगा इसकी कोई रिट अपील लगी है क्या?
The WA has been filed.
हाँ?
WA 2182 of 2020.
लग गई ना?
लगी है. रिट अपील लगी.
संतोष.
हाँ संतोष. यस.
WA 2182 of 20.
WA
21.
वो तो मेरे को पढ़ते पढ़ते ही समझ में आ गया था.
It's pending. Pending it.
But I'll just check that.
WA
2182 of 23.
23.
I'm sorry, sir.
नहीं,
अच्छा है.
when you read over, I understood that this is a case.
और उसके रिपरकशंस पे
इस ऑर्डर में तो आपकी रिलायंस बहुत मदद नहीं करेगी. जैसे ही आपने वहां पढ़ा
The stay by the division bench on 4/12/23.
Stay dated
4/12/23. In view of the maintained parity, the effective operation of the MP not dated 3/10/23 passed in WP number 2634/20 shall remain state.
मिस्टर आदित्यवीर सिंह, क्या करते हैं आप? स्टेट जजमेंट को आप दे रहे हैं सीनियर को बहस करने के लिए। चले, तो अब इससे कुछ अलग हटके बताएं।
जी, मैंने सर शुरू में कहा था, उस समय मुझे मालूम नहीं था कि ये जजमेंट स्टे हो गया है। मैंने आपसे कहा था ओनली फॉर फ्यू पर्पसेस।
हाँ हाँ, ठीक है, ठीक है।
नाउ माय सबमिशन इज दिस।
मेरा हंच तो मैंने पहली लाइन पढ़ के ही मैंने समझ लिया था
जी।
कि कुछ ना कुछ होगा, लेकिन मैंने कहा कि आपको बीच में टोकना उचित नहीं है। बट व्हेन यू केम टू द कंक्लूजन, देन माय हंच ग्रू सो मच दैट आई कुड नॉट withhold my apprehension and ask this question कि WA लगी कि नहीं लगी और क्या हुआ।
हालांकि इसमें कोर्ट ने बाद में ये कह दिया था कि गुजरात में जो है, गुजरात में सेक्शन 203 है सर पंचायत राज अधिनियम का, जो अपने यहाँ नहीं है। उसमें उन्होंने कहा कि these employees will be treated as
62, 65 के नियम अलग थे।
हाँ वो अलग, बिल्कुल। तो
We are governed by 1993 rules।
वी आर गवर्नड बाय 1993 रूल्स। और दूसरा सर
और पंचायत के जो नियम हैं, जो भी बने हैं सर्विस नियम, वो आर्टिकल 309 में नहीं बने हैं।
नहीं है सर, वो तो दे आर अंडर दी पंचायत राज अधिनियम
एक्ट अधिनियम में बने हैं, इसलिए 309 की भी एनालॉजी जो है
नहीं, वो नहीं है सर। और दूसरा इसमें एक चीज और है सर, कोर्ट ने रिकॉर्ड किया है इसको पैराग्राफ 8 में,
हाँ
कि पंचायत राज अधिनियम में जो वहां पर गुजरात में था,
हाँ
गुजरात में उन्होंने लिखा है सर, इट हैज बीन एड दैट पंचायत सर्विस रिक्रूटमेंट रूल्स अंडर सेक्शन 203 ऑफ गुजरात पंचायत एक्ट 1962 वाज अ सिविल सर्विस।
जी जी,
वहां पर इट वाज अ सिविल
हाँ वो तो यहाँ पर भी लिखा है ना, जहाँ पर पढ़ रहे थे,
हाँ,
वहां पर भी
लिखा है सर।
यहाँ पर भी लिखा है ये।
इट्स नॉट अ सिविल सर्विस।
जी, ये पेज 10 पे पढ़िएगा, 119 पैरा जो है।
जी,
This court in Ramanlal case noted that the panchayat service constituted under section 203 of the Gujarat Panchayats Act was a civil service of the state and the members of the service were government servants।
हाँ।
So the 203 specifically provided for that।
वहां पर बिल्कुल सर
हाँ।
उन्होंने कहा ये सिविल सर्विस। इसलिए कोर्ट ने सर इसको यहाँ डील भी किया कि वी विल नॉट एग्री विद दैट प्रपोजिशन। नाउ इसमें सर मेरा सबमिशन ये है, आई जस्ट रेड इट माय लॉर्ड इन पैरा 8 my lords, that the state government may entrust certain of its responsibility to the panchayat. Similar is the situation here, that the responsibility of running these institutions was entrusted by the state government to the panchayats, and therefore despite the fact that the schools were put under the control of the my lord panchayats and local bodies, it was a responsibility of the state government to run the institution under the constitution, and therefore my lord, the institutions were still my lord the government institution
जी,
and therefore my lord ये सेक्शन, इसमें जो पैराग्राफ 8 में उन्होंने लिखा है कि सेक्शन 51 and 52 deals with the entrustment of certain functions of
paragraph 8 of this judgment only।
this judgment।
अरे अब तो ये स्टे है, इसको पढ़ने से
इसको इस पर्पस के लिए पढ़ रहा हूँ, मतलब that judgment is a state, that's different matter, but the legal proposition what the court has said।
नहीं, now that whole legal proposition is subject matter of test before the division bench। So
जी नहीं मैं तो सर ये देखिए ना, सेक्शन 51 सेक्शन 52 मैं तो सिर्फ ये मैं इसका पंचायत राज अधिनियम से पढ़ रहा हूँ।
हाँ, पंचायत राज अधिनियम दिखाइएगा, दीजिएगा, पंचायत राज अधिनियम दीजिएगा प्लीज, ये मैनुअल 1, यस, हाँ इसी को दीजिएगा। जी,
सेक्शन 51 अगर आप
यहाँ प्लीज पढ़िए।
Sir, entrustment of certain functions of the state government to Janpad Panchayat. The state government may entrust a Janpad Panchayat, Jila Panchayat functions in relation to any matter to which the executive authority, the state government extends, or in respect of the functions which have been entrusted to the state government by the central government, and the Janpad Panchayat or Jila Panchayat shall be bound to perform such functions. It shall have necessary power to perform such functions. Where functions are entrusted to a Janpad Panchayat or Jila Panchayat under subsection 1, the Janpad Panchayat or Jila Panchayat shall, in the discharge of those functions as an agent of the state government, there shall be paid the state government, be paid by the state government to the Janpad Panchayat, Jila Panchayat, such sum as may be deemed necessary for discharging the functions entrusted to it under this section. The Janpad Panchayat, Jila Panchayat shall, for the purposes of discharging the functions entrusted to it and under this section, be under the general control of the state government or any other authority appointed by it, and shall comply with such directions as may be from time to time be given to it.
जी
So section 51, my lord, it gives the power to the state government that the state government may entrust certain of its functions, my lord, having the administrative control over those functions. And the funds will be provided by the state government,
जी
which is the situation here, my lord.
जी
The salaries and all those benefits, my lord, whatever has been given to them,
जी
if my lord should see that all benefits, including my lord, the revisions of the pay scales, then grant of Kamonati, time scale pay, everything has been interest, my lord, paid by the state government.
जी है क्योंकि शासन ने तो जवाब दिया नहीं, तो अब हमें ही रिसर्च करनी है। तो वहां से शुरू करते हैं कि वो स्कीम क्या कहती है। आप लोग ऐसा क्यों करते हैं? आपके यहाँ ये भी नहीं समझा जाता कि कौन सा केस किसको मार्क करना है, किसकी क्या कैपेबिलिटी है? एक मिनट रुक जाइए।
P4 is 97, से पहले 96।
डिविजनल डिप्टी कमिश्नर जवाब बना रहे हैं, और क्या कहा इन्होंने जवाब में? थोड़ा 2 मिनट जवाब ही देख लो।
सर जवाब अगर आप देखेंगे
जी
पैराग्राफ 4 से देखेंगे सर।
जी
Answering respondent most respectfully submit that in the case in hand, petitioner number 1 is an association of teachers and employees of institutions of primary and secondary education working under the tribal development department of the state government. The petitioner number 2 is working as Prathmik Shikshak and presently posted in primary school under the control of the school education department. The present petition is being filed challenging the application of the national pension scheme in respect of the members of petitioner number 1 association, and the state president of the association has been authorized in this behalf by the executive committee of the association by resolution dated 30/10/2019. Answering respondent most respectfully submit that the school education department 2005-2011 issued an order addressed to all collectors, commissioners, municipal corporation, chief executive officer, Jila Panchayat, the chief municipal officer, assistant commissioner, tribal development, and the chief executive officer, Janpad Panchayat, providing for inclusion of Adhyapak Samvarg in the national pension scheme. It is categorically stated in the order that the state government has taken a decision to include the Adhyapak Samvarg, whether appointed under the Panchayat Adhyapak Samvarg Rules 2008 or MP local bodies Adhyapak Samvarg Rule 2008. In part 1 of the order, it was stated that the scheme was compulsory for all सहायक अध्यापक, अध्यापक एंड वरिष्ठ अध्यापक वर्किंग इन द गवर्नमेंट।
देख लिया मैंने, देख लिया।
एक्चुअली हमने हमारी petition से
हाँ वही तो
इसमें रिप्लाई में कुछ नहीं है। none of the contentions have been
none of the grounds have been answered. जी बताइए क्या कहना है आपको?
R1 में भी
हाँ R1 बताइएगा। R1 में
notification
हाँ
Rules of 2008.
पढ़िएगा।
Adoption is being sanctioned of all those Samvida Shikshak Karmi grade 1 and grade 2
जी
that to be given effect from 1/1/8/2008 and
जी
the relevant page is page number 10,
जी
rule 5 subclause 4.
पढ़िएगा।
So it speaks that every person merged in Adhyapak Samvarg on dated 1/4/2007
while fixing his pay in Adhyapak Samvarg, a person having 3 years continuous service as a Shiksha Karmi shall be given the benefit of 1 increment in Adhyapak Samvarg. So we have considered, because Samhita Shala Shikshak were the contractual employee, we considered their service tenure and we granted 1 increment prior to absorption, which has been given into effect on 1/4/2008. And as per their undertaking also, sir.
Where is the undertaking?
In other petitions, undertakings have been,
क्या undertaking है?
sir, कि सर 50.2 में अंडरटेकिंग्स हैं, उसमें उन्होंने बोला है कि they will abide by all rules and regulations which are the same thereon and after absorption, whatever the conditions have been applied will be abide by the petitioners. 50.2 में दिया हुआ है. There are, apart from this, the rule at R2 at page number,
डिस्कनेक्टेड मैटर में बता रहे हैं आप?
sir, 50.2
50.2 में
सर, उसमें जो एनेक्शर पेज नंबर कंप्लीट, पेज नंबर 9
जी,
R2.
यस, पढ़िएगा.
मैं प्रहलाद डेहरिया, सो एज क्लॉज 1 से पढ़ूंगा. मैं जनजाति कार्य विभाग में नवीन नियमों के तहत नियुक्त किए जाने की सहमति प्रदान करता हूँ. मेरे विरुद्ध किसी भी प्रकार की अनुशासनिक कार्रवाई, विभागीय जांच प्रचलित नहीं है. मैं दिनांक 1/7/2018 की स्थिति में किसी भी प्रकार के दंड की
इससे क्या बताना चाह रहे हैं आप?
सर,
इससे बताना क्या चाह रहे हैं? थोड़ा समझा तो दीजिए पहले. भाई वो तो समझ में आया आपका R1 जो आपने लगाया है, वो तो समझ में आया. गजट नोटिफिकेशन है, आपने अध्यापक संवर्ग में संविलियन किया, यहाँ तक तो समझ में आया. ये R2 से क्या बताना चाह रहे हैं? थोड़ा समझाइए. इस अंडरटेकिंग से क्या होगा?
सर, they will be abiding with the
आपका एक एफिडेविट लिखवा दें कि आप आदमी नहीं है, तो वो एफिडेविट आपके ऊपर बाइंडिंग हो जाएगा.
and sir,
नहीं, एक सेकंड बताइए ना प्लीज. इस शासन इस प्रकार का इररिलेवेंट बहस क्यों करता है? प्लीज बताइए ना कि हाउ दिस अंडरटेकिंग टू विच यू आर ड्राइंग अटेंशन ऑफ दिस कोर्ट इज रिलेवेंट. फाइल पढ़ी थी नहीं पढ़ी थी? तो फिर ये बताओ ना, फिर सवाल का जवाब दो ना. व्हेन यू आर रेफरिंग टू R2, देन हाउ दिस अंडरटेकिंग इज रिलेवेंट?
my contention with regard to this, there is a declaration by the petitioner that they will abide by all the rules and laws prevailing at the time of absorption.
मैं आपसे यही तो बोल रहा हूँ.
It is not,
एस्टॉपल होता है क्या लॉ में? अगर उनका कोई लीगल राइट है तो क्या आप इस अंडरटेकिंग से उसको जो है खत्म कर देंगे? चलिए, लेट अस कम टू अ लार्जर क्वेश्चन. इज देयर एनी प्रिंसिपल ऑफ एस्टॉपल अगेंस्ट लॉ? है? तो फिर R2 का क्या रिलेवेंस है?
answer in this item number 50 R2 kindly visit
हाँ, आइटम नंबर 50 देख लेते हैं. चलिए देखते हैं 50.
9/10/2019.
एक मिनट देखते हैं, प्लीज खोलने तो दीजिए. R2 देखने दीजिए.
dated
Yes.
9th of October 2019.
हैं? हाँ
Page number 12.
जी,
Relevance is at page number 40.
पेज नंबर 14
Clauses 2.11.
पढ़िएगा.
नवीन संवर्ग के लिए वर्तमान में अध्यापक संवर्ग हेतु प्रभावशाली राष्ट्रीय पेंशन योजना यथावत लागू रहेगी. योजना के प्रावधान अनुसार शिक्षकों के अंशदान तथा नियोक्ता अंशदान यथास्थिति संचालनालय कोष एवं लेखा तथा संचालनालय पेंशन द्वारा निर्धारित की गई प्रक्रिया अनुसार NSDL को प्रेषित कीजिए. This
ठीक.
contention is with regard to giving effect to a new NPS system applicable for the petitioners with regard to our.
ठीक, चलिए. एनीथिंग एल्स? हैं? ये आपको और क्या कहना है गिलियाल साहब?
मेरा सबमिशन ये है सर कि as I read one of section 51,
जी.
under section 51, it was only the
Effective control is of the state government, therefore they are to be treated as a state government servants from the date of their initial appointment. चलिए, दिखाएं आप. जी. these bunch of petitions is filed by the petitioners who were initially appointed as Shiksha Karmi under the scheme of Shiksha Karmi 1996. Annexure बनाया है क्या शिक्षा कर्मी स्कीम?
97 के रूल्स हैं उसके
हाँ, नहीं।
96 में पहले रूल है फिर 96
हाँ,
में rules हैं।
96, which were later on amended and whose service conditions were governed by the Shiksha Karmi rules 1997. Annexure
P4
P4.
Page 30.
अच्छा, ऊपर सबसे पहले लिख लेना that these bunch of petitions, ऐसा इसको अभी रहने दीजिएगा. These bunch of petitions raises a common issue that petitioners who were initially appointed as Shiksha Karmis and later on Samvida Shala Shikshak and thereafter were absorbed in the cadre of Adhyapak.
मतलब संविदा शाला शिक्षक was cadre equivalent to शिक्षक
हाँ.
शिक्षा कर्मी was replaced by the
अभी मैं बेसिक लिखा रहा हूँ, देखिएगा सब आएंगे, सारे फैक्ट्स आएंगे. अभी एक पैराग्राफ सही लिखा लेने दीजिए, फिर दिखाता हूँ मैं. कहीं गलती होगी
नहीं बने संविदा शाला शिक्षक.
हाँ ठीक है,
कुछ लोग शिक्षा कर्मी बने, कुछ लोग
अच्छा ठीक है, क्या लिखा? शिक्षा कर्मी ऑब्लिक संविदा शाला शिक्षक कर लीजिएगा. Who were later on absorbed as in the Adhyapak Samvarg with effect from 1/4/2007 have become government servants with formation of Rajya Shaikshanik Samvarg in the year 2018, which has 3-tier system of Prathmik Shikshak, that is primary teacher, Madhyamik Shikshak, that is middle teacher, and Uch Madhyamik Shikshak, that is higher secondary teacher. Full stop. It is submitted that since petitioners have become government servants, they are entitled to the benefit of the Madhya Pradesh Civil Services Pension Rules 1976, which was applicable to all the employees of the state government who were appointed prior to 1/1/2005. 1/1/2005 ही है ना डेट, कट ऑफ डेट इसको 1/1/2005. Full stop. It is submitted that since petitioners were appointed prior to 1/1/2005, therefore, on their merger with the state government, they are entitled to the old pension scheme. Next para. WP 10444 of 2020 Tribal Welfare Teachers Association versus State of MP is taken as a lead case, and all the documents referred to herein will be the documents from this petition. Next para. Shri Gildial submits that Madhya Pradesh Panchayat Shiksha Karmis Recruitment and Conditions of Service Rules 1997 were framed by the state government in the year 1997. Some of the petitioners were appointed under those rules and some others under the Samvida Shala Shikshak rules. Annexure लगाया है क्या?
संविदा शाला वाले
अच्छा, संविदा शाला शिक्षक अंडर द रूल्स ऑफ 2001. रूल्स का पूरा नाम लिख लीजिएगा. नेक्स्ट पैन एक सेकंड देख के बता देता हूँ. That is Panchayat Samvida Shala Shikshak within bracket appointment and conditions of contract bracket close rules 2001. Next para. It is submitted that thereafter Madhya Pradesh Panchayat Adhyapak Samvarg within bracket employment and conditions of services bracket close rules 2008 were brought into force as are contained in annexure P5, and there was a scheme that Shiksha Karmi grade 3 will be absorbed as Sahayak Adhyapak, Shiksha Karmi grade 2 as Adhyapak and Shiksha Karmi grade 1 as Varisht Adhyapak. Full stop. The analogous provisions were taken from the rules of 2001. Full stop. Petitioner thereafter in the year 2018 Rajya Shaikshanik Samvarg has been prepared and इसके rules कहाँ हैं राज्य शैक्षणिक संवर्ग के? In the year 2000 have been enforced in the year 2018. कहाँ है वो rules? And now there is a common cadre, namely Rajya Shaikshanik Samvarg, full stop. Next paragraph. Petitioner's contention is that after becoming part of Rajya Shaikshanik Samvarg, they are entitled to be treated retrospectively from the date of their initial appointment to be members of the state civil service, entitling them to the benefits as are admissible to the civil servants under the Madhya Pradesh Civil Services Pension Rules 1976, and to support this submission, reliance is placed on Section 51 of Madhya Pradesh Panchayat Raj एवं Gram Swaraj Adhiniyam 1993. Full stop. Next paragraph. Reading from Section 51 of the Panchayat Raj एवं Gram Swaraj Adhiniyam 1993, herein after referred to as the Act of 1993, it is submitted that the state government has been given authority to entrust to a Janpad Panchayat or Jila Panchayat functions in relation to any matter in which the executive authority of the state government extends, or in respect of functions which have been entrusted to the state government by the central government, and the Janpad Panchayat or Jila Panchayat shall be bound to perform such functions, full stop. It shall have necessary powers to perform such functions, full stop. Next paragraph. Reading subsection 2 of section 51, it is pointed out that since the functions which are entrusted to a Janpad Panchayat or Jila Panchayat under subsection 1 bracket में ले लीजिएगा, the concerned Janpad Panchayat or the Jila Panchayat has to act as an agent of the state government, and they are to be paid by the state government such sum as may be deemed necessary for discharging the functions entrusted to it under this section. Therefore, and in view of the provisions contained in subsection 4 of section 52, where there is a provision for general control of the state government or any other authority appointed by it, it is submitted that de facto petitioners have been employees of the state government and therefore they are entitled to
I requested him to take that MPLT 2018 rules.
अच्छा देख लीजिएगा, चलिए क्या लिखा? By the state government, therefore to count for all the benefits which accrued to a civil servant under the state. Next paragraph. सुनिए फंडामेंटल रूल्स निकाल के दीजिए और पेंशन रूल्स निकाल के दीजिए 1976 के. Next paragraph. In this backdrop, petitioners are challenging the action of the respondents in keeping them under the fold of the National Pension NPS managed by National Securities Depository Limited, which is a contributory pension scheme floated by the state government for those who have been appointed in the services of the state after 1/1/2005. Next paragraph. Reliance is also placed on a judgment of a coordinate bench of this High Court at Indore in WP 2634/2020, decided on 3/10/2023, where the issue was that whether the employees of Gram Panchayat, Janpat Panchayat and Jila Panchayat are to be treated at par with state government employees in respect of date of implementation of recommendation of the 6th Pay Commission, and the ancillary issue was under which authority the state government is competent to fix the date of implementation for the members of Panchayat services. Next para. Reading extensively from this judgment, it is pointed out that a coordinate bench of this High Court, placing reliance on the judgment of Supreme Court in State of Gujarat versus Raman Lal Keshav Lal Soni, 1983 to SCC 33, held that when personnel are drawn from different sources, namely, government departments, as well as, the local authorities or municipalities merged together to constitute a single integrated civil service under the state by a legislative enactment, would become the state government employees irrespective of their original status, full stop. The question was answered in the affirmative. Next para. It is submitted that in this very judgment of Raman Lal, it was noted that the Panchayat service in Gujarat constituted under section 203 of the Gujarat Panchayat Act 1962 was a civil service of the state, and members of the service were government servants. And taking that analogy, Honorable Coordinate Bench of this court at Indore in WP 2634 of 2020, in view of the fact that the state of Madhya Pradesh has control to make rules and regulations for recruitment in panchayats, and the services provided to the citizens residing within a rural area, the panchayats are constituted under Article 243B of the Constitution, therefore those benefits which the state government provides to all citizens of Madhya Pradesh through various departments by recruiting employees, the same facilities, services have been given by the panchayats through its employees, held that the employees of panchayats are also. Thus, it is submitted that though petitioners were initially appointed under the provisions of the Madhya Pradesh Panchayat Shiksha Karmis within bracket recruitment and conditions of service bracket close rules 1997, but since initially the state government run schools were handed over to the panchayats, the effective and actual control being that of the state government, they all will be treated to be the state government servants. Next para. Shri Amit Mishra, learned panel lawyer for the state, in his turn submits that petitioners are not entitled to any of the relief claimed by them. Full stop. He admits that the reply filed in this petition is cryptic and does not answer any of the issues raised by the petitioner directly, but at the same time, he leaves no stone unturned to defend the action of the state on the ground that by no stretch of imagination, employees of panchayat can be termed to be government employees. And even if they are merged with the state government, as has been sought to be made out by Shri Gildial, referring to the provisions of some scheme of 2018 by which Rajya Shaikshanik Samvarg has been created, but that being after 1/1/2005, they will be still governed by the NPS scheme and not by the pension rules of 1976. Next para. After hearing learned counsel for the parties, first issue is that as far as order of the coordinate bench passed in WP 2634 of 2020 is concerned, that has been stayed by a Honorable Division Bench of this High Court by order dated 4/12/2023 in WA 2182/23. Next paragraph. Secondly, on facts of the case which are narrated and the reliance of on the judgment of Supreme Court in case of Raman Lal Supra, it is evident that those facts are distinguishable from the facts of the present case. Full stop. In that case, Panchayat service was constituted under Section 203 of the Gujarat Panchayats Act 1962 as a civil service under the state. Full stop. That being the distinctive factor, because in the present case, the rules of the 1997 categorically provides that in exercise of the powers conferred by clause within bracket small b bracket close of subsection 1 bracket में of section 53 comma subsection 1 of section 70 read with section 1 subsection 1 bracket में of section 95 of Madhya Pradesh Panchayat Raj Adhiniyam 1993, the state government makes the following rules, namely the Madhya Pradesh Panchayat Shiksha Karmis Recruitment and Conditions of Service Rules 1997. Full stop. In the definition clause 2, Shiksha Karmi is defined under section 2 within bracket small h bracket close to mean a person appointed by Jila Panchayat or Janpad Panchayat as the case may be for teaching in the schools under their control. Full stop. Rule 5 deals with methods of selection and recruitment, and sub-rule 8 of Rule 5 provides that the selection committee shall be constituted consisting of members as specified in Schedule 2 by the Jila Panchayat or the Janpad Panchayat as the case may be. Full stop. Normally, the selection, full stop. And then the procedure has been given in sub-rule 9 as to how suitability of the candidates will be assessed and marks will be given. Full stop. These appointments are to be made on probation for a period of 3 years as is provided under Rule 7. Full stop. Rule 9 provides that discipline and control will be under the administrative that will be that of the Jila Panchayat or Janpad Panchayat as the case may be. Full stop. The General Administration Standing Committee of the Jila Panchayat or Janpad Panchayat as the case may be shall be the disciplinary authority for major punishment and the chief executive of the Panchayat for the minor punishment. Full stop. Thus, it is evident that nowhere these rules provide for constituting a service under the state government. A distinct service has been created under the rules of 1997, which continued in a different and rechristened form in the name of Samvida Shala Shikshak को नाम लिखाया था मैंने आपको 2001 इतना. Next paragraph. Thus, this being the difference, and therefore the law laid down in case of Raman Lal Supra has no application to the facts and circumstances of the present case. Next paragraph. As far as the Madhya Pradesh Civil Services Pension Rules 1976 are concerned, these rules in section 2, rule 2 provides that these rules shall apply to every government servant appointed to civil services and posts in connection with the affairs of the state of Madhya Pradesh and who are born on establishments not declared as non-pensionable. Full stop. Thereafter, it is provided in rule 2 itself that these rules shall not apply to colon dash. ये rule 2 उठा लेना, पेज 317 पर है. इसमें A से G तक कैटेगरीज दी हुई हैं, वो कॉपी कर दीजिएगा. Full stop. Thus, it is evident that clause E provides that persons employed on contract, except when the contract provides otherwise, are not covered under the Madhya Pradesh Civil Services Pension Rules 1976. Full stop. Thus, admittedly, when petitioners were appointed on contract under the provisions of the Madhya Pradesh Panchayat Shiksha Karmis Recruitment and Conditions of Service Rules 1997 and thereafter under the rules of 2001 meant for Samvida Shala Shikshak, then they are not covered by the rules of 1976. Full stop. Even otherwise, if petitioners were to contend that they are covered by the rules of 1976, then they should have agitated this matter in the year 1997 or soon after their appointment, in as much as clause F provides that persons whose terms and conditions of clause F of rule 2 of the pension rules provides that persons whose terms and conditions of service are regulated by any other rules for the time being in force shall be excluded from the operation of the civil service pension rules. Next para. Thus, admittedly, these rules of 1976 have no application to the Constitution, to the facts and circumstances of the case. Next para. Reliance of the coordinate bench on the provisions contained in Article 243 E and 243B, 243C, etc. is concerned. Article 243E, D defines a panchayat as an institution of self-government constituted under Article 243B for the rural areas. Next para. Article 243B, which deals with constitution of panchayats, provides within bracket 1, there shall be constituted in every state, panchayats at the village, intermediate and district levels in accordance with the provisions of this part. Full stop. Article 243C deals with composition of panchayats and provides that subject to the provisions of this part, the legislature of a state may, by law, make provisions with respect to the composition of panchayats, provided that the ratio between the population of the territorial area of a panchayat at any level and the number of seats in such panchayat to be filled by election shall, so far as practicable, be the same throughout the state. Full stop. Next para. Article 243G deals with powers, authority and responsibilities of panchayat. Full stop. It provides that subject to the provisions of this constitution, the legislature of a state may, by law, endow the panchayats with such powers and authority and may be necessary to enable them to function as institutions of self-government, and such law may contain provisions for the devolution of powers and responsibilities upon panchayats at the appropriate level subject to such conditions as may be specified therein with respect to dash within bracket small a, the preparation of plans for economic development and social justice, semicolon, B within bracket, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the matters enlisted in the 11th schedule. Full stop. Next paragraph. Thus, a plain reading of Article 243G makes it abundantly clear that mere delegation of certain powers and authority to enable them to function as institutions of self-government will not take away the autonomy of the Panchayat Raj institutions, and they will still be autonomous in the matter of preparation of plans for economic development and social justice, and also implementation of schemes for economic development and social justice as may be entrusted to them. Next para. Thus, when this autonomy is considered in view of the provisions contained in Article 243 capital I, which deals with Constitution of Finance Commission to review financial position, and Article 243J, which deals with audit of accounts of panchayats, leaves no iota of doubt that though some grants or considerations may be doled out to the panchayats by the state government, but their financial autonomy was sought to be kept intact by the framers of the constitution, and in that view it cannot be said that the panchayats have subrogated their authority and have merged their identity with the state government. Full stop. Since their identity is not merged with that of the state government, their employees cannot seek to get their identity merged with the state government, so to seek the benefit of pension. Next para. When all these aspects are examined, then in terms of the provisions contained in the Madhya Pradesh Panchayat Adhyapak Samvarg Employment and Conditions of Service Rules 2008, it is evident that Adhyapak Samvarg has been defined in clause 2F as the person employed or merged by Jila Panchayat or Janpad Panchayat for teaching in the schools under their control. Full stop. Similarly, next para. Similarly, section 2G defines Shiksha Karmi as a person appointed for teaching by the Jila Panchayat or Janpad Panchayat, as the case may be, under the Madhya Pradesh Panchayat Shiksha Karmi within bracket recruitment and conditions of service bracket close rules 1997. Full stop. Similarly, section 2H defines Samvida Shala Shikshak to mean a person employed / appointed by Jila Panchayat or Janpad Panchayat, as the case may be, under the Madhya Pradesh Panchayat Samvida Shala Shikshak within bracket condition of employment and contract bracket close rules 2005 for teaching in the schools under their control. Full stop. These three definitions leave no iota of doubt that Shiksha Karmis or Samvida Shala Shikshak or Adhyapak Samvarg is a category of persons which were meant for teaching in the schools under the control of Jila Panchayat or Janpad Panchayat. Full stop. They are not under the control of the state government, and by no stretch of imagination they can be said to be the civil servants in terms of the definition of civil servants given in the Fundamental Rule 3. दिखाइएगा Fundamental Rules दीजिएगा. fundamental rule 3, full stop. Next para. Fundamental rule 2 provides that the fundamentals rule apply to all government servants whose pay is debitable to civil estimates in India, full stop. In the present case, pay and allowances of a panchayat, shiksha karmi, or a person belonging to Adhyapak Samvarg or Samvida Shalak Shikshak is not debitable to the civil estimates in India or to the civil estimates of India, and therefore they are not amenable to the fundamental rules of the state, full stop. And therefore the pension rules, they being not a civil servant, pension rules will not be applicable to them. Pension rules of 1976 will not be applicable to them, full stop. In view of such facts, even if their merger in the year 2018 is taken to be with the state government as canvassed by SHRI Gildial, but for which no material is brought on record, comma, still by virtue of the operation of the provision contained in clause 2 G of the Civil Service Pension Rules 1976 as amended, as inserted by order dated 2/4/2005, और ऊपर जो वो डेट 1/1/2005 आ रही है ना, वो 1/4/2005 हो जाएगी. Comma, even if hypothetically petitioners are treated to be government servants for which there is no material on record, still they will not be governed by the pension rules of 1976, and therefore their claim for grant of pension under the rules of 1976 cannot be accepted. Petitions fail and are dismissed.
मतलब just to put the records straight, एक तो वो मेरा सबमिशन रह गया कि all these institutions are the government institutions.
लिखा है मैंने. They were government, they were taken over by the panchayat, and therefore they continue to be government. लिखा है मैंने.
मैंने सिर्फ इतना कि because all these institutions are the government institutions
जी.
and there was no government institution after that.
इतना लिख लेना एक जगह पर ऊपर submissions में. Petitioner's contention is that since these schools were taken over from the government were handed over by the government to the respective panchayats, they did not lose their original character of government institutions. और बताइए.
जी दूसरा सर वो 18 के जो रूल्स हैं उसमें इट्स जस्ट टू पुट द रिकॉर्ड्स स्ट्रेट, क्योंकि उसमें दो सेट बने थे रूल्स के, स्कूल एजुकेशन के अलग थे और ट्राइबल के अलग. तो वो 18 के रूल्स में इतना आ जाएगा ताकि क्योंकि
18 में लिख लीजिएगा. There were two sets of rules, one for the school education department and another for the tribal department.
These petitioners are from the tribal department.
तीन petitions हैं, तीनों tribal के हैं क्या?
Tribal.
हाँ, and these petitions are from the tribal development. है? अरे छोड़ दीजिए, वो मत लिखिए these petitions are from tribal, ही मत लिखिए.
खाली दो सेट हैं रूल्स के.
ठीक है. चलो, thank you.
ग्रेट.
Thanks for your cooperation. मेंशन केसेस उठाइए जल्दी से.
किशन कुमार गौतम,
बताइए गौतम जी.
Lordship, he is seeking third time pay scale in by this petition. Document of hearing on 7/2010. They have granted lost indulgence for filing the file.
रिप्लाई नहीं आया क्या? देखिएगा, श्री के गौतम फॉर द पिटिशनर, ये आ गया रिप्लाई आपका?
There is one thing which has to be brought to the knowledge of the
जी.
Supreme Court. This petition, my lord, the last annexure which has been filed by the petitioner is the representation given to the part.
जी.
That was decided in the year April 2021 itself.
हाँ ठीक है,
never been challenged by the petitioner.
ठीक है, आप जवाब नहीं देना, आपको ऐसा लिख के फिर डिसाइड कर देते हैं.
Just submitting this.
देखिए, state has not filed reply till date. Full stop. Shri Ankit Agarwal orally submits that petitioner's representation was rejected in the year 2021, but same has not been challenged by the petitioner till date. Next para. Irrespective of the fact that what was the fate of the representation, the state was obliged to file reply, especially when on 7/12/23, by way of last indulgence, a coordinate bench had granted 4 weeks time to file reply. Full stop. Since the reply is not filed, subject to payment of cost of rupees 5,000, दे दीजिएगा 4 weeks का time. List in the week commencing 8 अप्रैल 2024. चलिए नेक्स्ट केस.
Number 67.
Praying for time to file reply.
देखिए, श्री धीरज तिवारी प्रेस.
Requested appointment. He should be fired in the
लास्ट अपॉर्चुनिटी देता हूँ इनको. श्री केसी गिल्डियाल फॉर द पिटिशनर, असिस्टेड बाय, इनका नाम डाल लीजिएगा. इतना धीरज तिवारी प्रेस फॉर एंड बाय वे ऑफ लास्ट इंटेलिजेंस ग्रांटेड 2 weeks टाइम टू फाइल रिप्लाई. लिस्ट इन द वीक कमेंसिंग 18 मार्च 2024.
Number 74.
रिप्लाई आई नहीं, इनको पॉलिटिकल मैटर नहीं.
4 weeks टाइम टू फाइल रिप्लाई बाय वे ऑफ लास्ट इंटेलिजेंस कर दीजिएगा. चलिए
Number 78.
रिकवरी मैटर मैटर ये
इसका पोस्ट रिटायरमेंट रिकवरी है.
इनका इनने बॉन्ड 16 का लगाया, जबकि रिकवरी हमारी इससे पहले ही बॉन्ड.
ठीक है, सुनेंगे इसको. लिखिए, प्लीडिंग्स आर कंप्लीट, केस इज टू बी हर्ड फाइनली. लिस्ट इन द वीक कमेंसिंग 15 अप्रैल 2024 फॉर फाइनल. ऑन ऐसा कर दीजिए, 13 अप्रैल वर्किंग है, 13 अप्रैल 2024 लीजिए.
Number 79.
In this case, they have moved application for extension of time for my
एक्सटेंशन ऑफ टाइम किस चीज का?
compliance of last order. I'm paying 2 weeks further.
क्या ऑर्डर था? देखिएगा, heard on application for extension of time to comply order dated 17/2/2024 on request of Shri Manaswani Verma 10 days time is granted to make compliance. List on 20 March 2024.
Right.
Number 88.
My lord, may I be permitted, my lord? The senior counsel will address through VC, my lord.
क्या मैटर क्या है? मैटर क्या है? जोड़िए, वीसी से जोड़िए.
Am I audible to my lord? My lord?
जी बताइए, क्या मैटर क्या है?
My lord, we in fact we have to file the return, my lord, and the copy of the petition has not been supplied in complete, my lord.
अरे तो ये बात तो आपका जूनियर ही बोल देता.
Kindly give me 4 weeks time, my lord, to do it, my lord.
My lord,
सर लेकिन ये बात तो आपका जूनियर भी बोल सकता था.
सर मेरी भी तो अभिलाषा दर्शन करने की थी.
my lord, it is a held up case. My lord, trial is stayed.
अभी इसको कर देते हैं, चिंता क्यों कर रहे हैं आप? श्री अजय मिश्रा लर्नेड सीनियर एडवोकेट, नहीं श्री विकल्प सोनी फॉर द पिटिशनर. पिटिशन की कॉपी अभी दीजिए, सप्लाई करिए, अभी हाथ की हाथ करिए.
Yes.
हाँ. Supplies copy of the miscellaneous petition along with annexures to Shri Gaurav Tiwari. Full stop. Since copy has been handed over, now the plea raised by Shri Ajay Mishra's learned senior advocate appearing through video conferencing that copy was not available and therefore reply could not be filed is mitigated. Full stop. Let reply be filed within 10 days. List this case on 14 मार्च 2024।
My lord, may I pray for 15 days, my lord?
नहीं, बहुत है जरा आपके लेवल पे तो 10 दिन में तो आप पूरे हाई कोर्ट का जवाब बना दें। चलिए नेक्स्ट केस।
IR में करनी
हाँ, IR टू कंटिन्यू।
है नंबर 92 एक ओम शंकर पांडे
I'm bringing time to file reply.
None for the petitioner, despite mentioning the case for out of turn hearing. Shri Atul Dwivedi, panel lawyer, prays for and is granted 4 weeks time to file reply. चलिए next case.
नंबर 102 एक अदालत बाद है
None for the petitioner, despite mentioning the case for out of turn hearing.
Pleadings are complete, my lord.
Pleadings are complete. Petition is admitted for final hearing. List for final hearing in part B of the cause list as per his turn and seniority.
नंबर
states the order that challenge the election P1.
जी.
My lord, after my acquittal, the respondents have refused my joining.
Petitioner's contention is किस ग्राउंड पे कर सकते हैं आप? आपने क्या डिपार्टमेंटल इंक्वायरी करके टर्मिनेट किया था क्या?
नहीं, इनके खिलाफ जो है FIR रजिस्टर्ड
तो
हुई,
एक्विटल हो गया ना, ये बोल रहे
उसका
हैं।
एक्विटल हो गया
तो एक्विटल के बाद
सर।
लॉ बहुत सिंपल है, अगर आपने डिपार्टमेंटल इंक्वायरी की है तो ठीक है, अदरवाइज आप इनको कैसे रोकेंगे?
But the offense registered against the petitioner is more is
वो तो
under the
आपके खिलाफ भी रजिस्टर हो सकता है और किसी के खिलाफ भी हो सकता है। फिर कोर्ट के एक्विटल का क्या मतलब रहेगा? If mere registration of an offence is a proof of committing that offence, then there is no need for a trial.
In fact, there was no order in writing of discharge of that I have pleaded in paragraph 5.3.
लिखिएगा. Looking to the fact that petitioner's contention that there was no order of discharge or no departmental inquiry pursuant to which he was discharged from service on registration of a criminal case 766/2020 under the provisions of section 294, 376 within bracket 2 another bracket N IPC and 325 or 325A SC/ST Prevention of Atrocities Act, and petitioner has been acquitted from the said charges by judgment dated 27/7/2022, respondents are required to file a personal affidavit that under which provision of law they can stop his reinstatement. Full stop. If any departmental inquiry was conducted, same be brought on record or appropriate orders be passed in that behalf. List in behalf of reinstatement.
the acquittal was the based on the basis of compromise.
हाँ ठीक है, 15 days. 15 days time is granted to do the needful. List after 15 days in the week commencing 8 अप्रैल 2024.
Matter of compulsory appointment, my lord. This is third visit of the petitioner, my lord. The two times this is
तो फिर वेट करिए, अभी तो
अभी pleading
फाइनल हियरिंग तो नहीं पाएगी.
Sir, this is a covered case, my lord. The malad is decided.
सॉरी, कवर्ड केस से मैं नहीं चलता हूँ, मेरे को सुनना पड़ेगा.
सिर्फ इतना ही है कि वो कौन सी पॉलिसी लगेगी, डेट ऑफ दी डेथ या डेट ऑफ दी, बस इतना ही से रिजेक्ट किया.
ठीक है, सुनेंगे इसको आपको. श्री राजेश कुमार सोनी फॉर द पिटिशनर. Readings are complete. Since this is a matter of compassionate appointment, list this case on 4 अप्रैल 13 अप्रैल कर दिए, 13 अप्रैल 2023 24 सॉरी,
कौन सी मिनट 24
13 अप्रैल 24. देखना 13 अप्रैल वर्किंग है ना, इफ आई एम नॉट रॉन्ग. उठाइए एक क्लिप उठाइए. हाँ 13 अप्रैल वर्किंग है. ठीक, चलते वर्किंग है 13 अप्रैल वर्किंग है. नीला हो रहा है ना ये ना. हाँ वर्किंग है. हाँ सोनी जी.
Malad, this is a better that Malad, the respondent passed the order and granted the benefit of the 7/10/2016 Malad, which is an Annexure P2. But the order has been issued, but the monetary benefit is not granted.
Petitioner's contention is that order has been issued on 29/11/2017, giving him benefit of GAD circular dated 7th October 2016, but monetary benefit has yet not been extended by the principal government OFK College, Jabalpur. Next para. This petition can be disposed of with a direction to the respondent number 3 and 4 that in case petitioner files a copy of the order being passed today within 7 days from today, then they shall consider and extend the benefit if there is no other impediment within further period of 30 days. In above terms, petition is disposed of.
Sir, इसमें notice भी हो गया था, but they have not filed any reply.
अरे कर दी आपकी petition ही dispose of कर दी.
ठीक बात.
दोनों ना 109.1 भी वही है ना.
Yes, Malad.
चलिए.
Malad, in this case, I am praying 2 weeks time to file reply in this.
हाँ लिखिएगा. श्री इतना सौगारा
Pension
praise
matter.
for and is granted 2 weeks time to file reply list after 2 weeks.
Obliged.
Praying for time to file reply.
Lordship, reply is awaited from the respondent.
I have appealed for response 5, I have filed my reply.
क्या हो गया? किसका reply awaited है?
Respondent.
State contesting party कौन है इसमें?
State is the contesting party.
अच्छा लिखिएगा reply of the state government is still awaited. Shri Piyush Bhatnagar for the state prays for and is granted 4 weeks time to file reply list after 4 weeks. This petition is filed
Malad,
seeking direction to decide petitioner's representation for
Malad, इसमें already direction हो चुका है. This is a 4th visit. Now
अच्छा,
every time that they have passed the
issue
order.
notice to the
सर
respondent.
नोटिस भी हो चुका है. ये रिप्लाई है. सबसे इनको रिप्लाई भी स्पेस करना है कि मॉनिटर 1/9/2016 से अभी तक क्यों नहीं दिया. जो डिटेल ऑर्डर है 28/11/2023 का.
क्या है दिखाइएगा क्या ऑर्डर है?
28/11/2023.
हाँ पूछ लेते हैं.
But then they have filed the reply and granted.
Within 4 weeks, my lord, a week.
Respondents have not responded to the earlier order dated 28/11/2023. They have not filed a reply till date. By way of last indulgence, 4 weeks time is granted to file reply list after 4 weeks.
Your Lordship, this is a case of compassionate appointment, Your Lordship. In this, the sole bread earner had died. Your Lordship, at the last date of hearing, Your Lordship, you had said that you had ordered the state that they may file
4
the
weeks
reply.
time to file.
Your Lordship, a fixed date may be given because it is an unreasoned order, Your
हाँ
Lordship.
ठीक है फिक्स डेट देंगे आपको. श्री आपका शुभ नाम भुवनेश
भुवनेश
शर्मा for the petitioner. Shri Saurabh Soni prays for and by way of last indulgence 4 weeks time file reply list on 13 April 2024.
This petition can be disposed of, in light of the reply preliminary submissions submitted by the respondents, my lord. In this preliminary submissions, my lord, they have taken a stand, my lord, that if this petition is allowed, they will be required to make a lot of logistical preparations, my lord, for letting these petitioners, my lord. My lord, short submissions may kindly be noted. It can be disposed of, my lord. Short submission is that, my lord. On 3 occasions, this examination is conducted.
तो बार-बार पोस्टपोन हो रहा है ये तो.
अभी फिर कर दिया है.
फिर पोस्टपोन हो गया लेकिन
अब 5 साल के बाद सर ये एग्जाम हो रहा है. एक इम्पोर्टेंट चीज बस नोट कराना चाहेंगे. इन्होंने पैरा 4 में ये लिखा है, पैरा 4 ऑफ देयर रिप्लाई, कि इन्होंने सेट के बच्चों को स्टेट
उनको एकोमोडेट करने के लिए इसको पोस्टपोन कर दिया.
एक बार किया.
तो आपका कहना ये है कि हमें भी एडजस्ट कर लो, हमारा भी
बढ़ा ही रहे हैं इतना, तो
अभी तो बढ़ा ही दिया ना,
बढ़ा ही दिया इन्होंने.
तो फिर आप एग्जाम पोस्टपोन हो गया तो फिर क्या
नहीं,
दिक्कत है?
एग्जामिनेशन पर वो पोर्टल खोलेंगे तभी तो हम अप्लाई करेंगे.
अच्छा,
My lords, my submission is that regarding para 4, my lords, I just stated that the
आप एग्जाम क्यों पोस्टपोन कर रहे हैं? चलिए आप जवाब दे दीजिए.
my lords, because
नहीं, why you are postponing? आपका जो रिप्लाई है,
my lords, the exam was postponed after the reply was filed because there was a litigation in a coordinate bench in
ठीक है,
Gwalior.
चल लिखा देते हैं ना, इसमें लिटिगेशन है, इसलिए subject to the litigation all the applicants will be allowed to participate. लिखिएगा.
My lords, my
As
submission
an
is that
interim measure, it is directed that petitioners be allowed to participate in the proposed entrance examination for appointment to the post of assistant professor, etc., to be organized by the Madhya Pradesh Public Service Commission, in as much as they have again postponed the conduct of examination in the garb of some litigation pending before the Gwalior bench of this High Court. Full stop. Since exam has been postponed, comma, in the garb of the litigation pending in the Gwalior bench, comma, respondent PSC can always declare a new date for conduct of examination, and prior to that they can receive applications by opening the portal, so to not to cause any discrimination, as is alleged by Shri Arpan Pawar that earlier date was postponed to accommodate the candidates who had appeared in the state eligibility test. Now petitioners are ones who have attained eligibility. कब attend किया आपने?
18/1/24.
On 18/1/24, and since exam has not been conducted and it has been postponed, signed I, comma, and Shri Pawar further submits that now elections are going to be declared soon, which will have the impact on the exams which are not going to be conducted before June 2024. Petitioners can be accommodated. Taking this view into consideration, this petition is disposed of, directing the respondent UPSC that if they are not conducting exam within the month of March 2024, then they will permit the others who attain eligibility to participate in the examination if the exam is to be held after 31st March 2024. With the aforesaid direction, petition is disposed of.
It's my one small submission, my lords, regarding that part wherein that we had not permitted set candidates who had passed. We had just made an arrangement that because they do not have a passing certificate, only a roll number can be filled.
ठीक है, वो तो accommodation तो है ही ना. रूल क्या है, लॉ क्या कहती है, उस तारीख को क्वालिफिकेशन होना चाहिए. आपके तो मत कहलवाइए, उतना अच्छा है. आप लोग नाउ स्टैट्यूटरी बॉडी के रूप में फंक्शन नहीं कर रहे हैं. आप लोग पॉलिटिकल बॉडी हो गए हैं जो कि अपने इंटरेस्ट को सर्व करने के लिए काम कर रहे हैं. यू आर नो मोर अ कॉन्स्टिट्यूशनल एंड स्टैट्यूटरी बॉडी. ये आपका कंडक्ट है.
Not in compliance of laws, last order, my lord, I've already supplied copy of this petition to Deputy Solicitor General. My lord, today,
Shri.
not today he informed that he cannot appear in this matter because he is not in the panel.
अरे पैनल ऑफ देखिएगा, श्री सार्थक नेमा in terms of the instructions dated 22/2/24 permits that he had supplied copy of the petition to the learned Deputy Solicitor General for Union of India. But today morning, Shri Pushpendra Dubey has informed him that Pushpendra Yadav has informed him that since he is not on the panel of the Union of India
Of Election Commission.
of the Election Commission, therefore he cannot appear in this matter. Next para. In view of such facts, issue notice to the respondent Election Commission of India. Full stop. Notices be served on Shri Siddharth Seth, who appears for respondent number 2, State Election Commissioner. वो State Election Commission के लिए होते हैं, उसके लिए भी नहीं होते. Issues notice to respondent number 1, 2 and 3 by both modes, that is registered AD post and Hamdast. Full stop. If PF be paid by tomorrow, कल working Saturday है ना registry का, by tomorrow, notices be prepared and handed over to the petitioner by Monday, he may serve the respondents हमदस्त by urgency है ना इस मैटर में आपको? हाँ, कितनी urgency है?
Lord, in few days, my lord, election program will be declared, my lord.
काय का election program?
General elections.
अच्छा, be served by 6th and affidavit be filed in this behalf. List on 7th March 2024. चलिए.
Not giving the charge of higher post to the deputy rangers, my lord, which is in pursuant to the circular dated 2023, which is annexure P5, my lord, at page number 76, my lord. In compliance of this circular, my lord, the DPC has been conveyed, my lord, but even then they have not been given the charge of promotional post, my lord. And whereas, my lord, the other employees, my lord, like forest guard, forester, and the even ranger have been given the charge of higher post, my lord.
Petitioner's grievances that petitioners are working. Petitioner is working.
Well, petitioner is the union, my lord. The
Petitioner is a union of
the employees working in a forest department and
employees working in the forest department. Full stop. Its members have not been given charge of the higher post of deputy ranger and ranger.
Only deputy rangers,
or deputy ranger, whereas other forest officials have been given higher charge. Full stop. It is submitted that even DPC has been convened, comma, yet promotion orders are not being issued, depriving the petitioners of their promotional avenues and an opportunity to serve on a higher post and discharge higher duties. Full stop. Notice is waived by Shri Manas Mani Verma, appearing for the state. He may seek instructions and file reply within 3 weeks. List this case in the week commencing 8 April 2024.
Number 152.
हमारा इसमें हमारा इम्प्यून ऑर्डर जो है P1 हमारा, जिसका रेफरेंस ऑलरेडी हमारा सिमिलर कोर्ट ऑलरेडी जो है ऑर्डर पास हो चुका है, उसके बाद SLP भी खारिज हो गई, रिट अपील भी खारिज हो चुकी है. P1 माइलर.
क्या ऑर्डर है
इसमें? इन्होंने माइलर एक सर्कुलर का हवाला दिया है, जो इनका कहना है कि 3/5/18 द्वारा मार्गदर्शन दिया गया था, जिसका इनका कहना है कि 3/5/18 के सर्कुलर से सेक्शन राइटर को राइट नहीं है माइलर कि 7/10/16 सर्कुलर का लाभ मिले. उसका मतलब ऑलरेडी पिटीशन हुई थी मतलब. ये P5 है मतलब. P5 में ऑलरेडी क्वेश्चन हो चुका है मतलब. पेज नंबर 31 मतलब. जी.
सर्कुलर को सिंगल बेंच सेटिसाइड कर सकती है क्या? और सर्कुलर का आपको वायरीज चेंज करना पड़ेगा? नहीं, मैं समझना चाहता हूं आपसे. मतलब सर्कुलर का जब तक आप वायरीज चेंज नहीं करेंगे, दैट इट इज अल्ट्रा वायरीज ऑफ सम प्रोविजन. एक सेकंड, समझना चाह रहा हूं. अरे सिंह साहब, कानून समझने का हमें भी तो अधिकार है, आपसे हम नहीं सीख सकते क्या? इस सिंगल बेंच ने सर्कुलर कैसे सेटिसाइड कर दिया? तो समझाइएगा तो हमको भी, तो पढ़ के आइएगा. रखता हूँ मंडे को.
उसके बाद मैं श्री 1 मिनट में ले गया था. इसमें नोटिस हो चुकी है, रिप्लाई आना शेष है मतलब. फिर नोटिस हो चुकी है.
क्या हो गया?
नोटिस हुई थी, रिप्लाई अभी तक.
अरे भाई वो सब ठीक है, हम तो समझना चाहते हैं कि सर्कुलर कैसे सेटिसाइड हो जाएगा. श्री
उसका रिट अपील भी खारिज हो गया.
हाँ ठीक है, बहुत अच्छी बात है. विनय प्रताप सिंह प्रेस फॉर टाइम टू आर्ग्यू दिस मैटर एंड पॉइंट आउट दैट whether without challenging the vices of a circular can it be set aside by a single judge in its writ jurisdiction. Full stop. Let this issue be prepared and addressed on, लगा दीजिए ट्यूसडे की डेट 5 मार्च 2024, टॉप ऑफ द लिस्ट. सुनेंगे ना वकील साहब आपको 5 मार्च को.
इसमें ये तक इनका रिप्लाई आ जाना है, स्टेट की रिप्लाई आना शेष.
इन द मीनवाइल स्टेट, अच्छा तो रिप्लाई आना है अभी.
जी मतलब
5 मार्च मत लगाइए. इन द मीनवाइल स्टेट में आल्सो फाइल इट्स रिप्लाई.
सेटल हो गया साहब, आपने आदेश कर चुके.
जी वही मेरा
क्या आदेश कर दिया?
सेक्शन राइटर को 7/10/16 का लाभ दिया जाए.
वो तो इसकी लाइट में कर दिया, लेकिन आज तो ये नया पॉइंट पकड़ में आया है.
ये दूसरा, ये बहस ही दूसरी कर रहे हैं.
ये बहस दूसरी कर रहे थे, तो अब इसका जवाब दीजिएगा आप. हाँ,
आपने ही पहले इसको
आपने डिसाइड किया सर.
डिसाइड किया, तो अब इसको इसकी लाइट में बिगड़ देखे कर दिया. आज टाइम था 3 मिनट का, तो देख लिया उसको।
मैं रिप्लाई देता हूँ।
रिप्लाई दीजिएगा इस
जी सर।
बिंदु का।
2 weeks my lord.
Shri Manas Mani Verma prays for and is granted 2 weeks time to file reply. List this case on 20 March 2024.
Reply.
इसको बुला लीजिएगा चैम्बर में, इसको मानस को चैम्बर में बुलाइए सर।
48 है।
हाँ बताइए।
फिक्स डेट केस है मैटर, इसको नेक्स्ट मंडे को सुन
क्या मैटर क्या बताइए।
इसमें वाला डायरेक्शन था, कंप्लायंस रिपोर्ट फाइल करनी थी।
हो गई आपकी रिपोर्ट?
वो कंप्लायंस रिपोर्ट फाइल किया, बट माय लॉर्ड वो जो है इन्होंने मेल मतलब वो प्रॉपर
कर रहे हैं साहब।
हाँ
मंडे कर।
ठीक है। श्री राजेंद्र प्रसाद गुप्ता 148 में 3 मैटर्स हैं कनेक्टेड। राजेंद्र Prasad Gupta for the petitioner submits that
आज ही
is
हमने
disputing the compliance filed by the state government on his request list on 4 March, top of the list.
नहीं, वो डायरेक्शन कैप्शन में आएगा 2:15 बजे।
Under the direction caption, top of the list.